Under the Securities Act of 1933, or the Securities Act, which prohibits the sale of unregistered securities, the term security is broadly defined to include notes, stocks, and investment contracts. In the 1946 case, Securities and Exchange Commission versus W.J. Howey Company, the United States Supreme Court established a three-part test for determining whether a scheme represents an investment contract under the Securities Act. Under the Howey test, a scheme is an investment contract if there's an investment of money, an expectation of profits, and the profits would arise solely from the efforts of others. Nearly 60 years later, in the 2004 case Securities and Exchange Commission versus Edwards, the court considered whether a scheme promising investors a fixed rate of return is an investment contract under the Howey test. Charles Edwards was the chairman, chief executive officer, and sole shareholder of ETS Payphones Incorporated, a company that sold payphones to the public. The phones were packaged with a site lease, 5-year leaseback and management agreement, and buyback agreement. Under the package, which all but a tiny fraction of purchasers chose, the phones were purchased for approximately $7,000 and leased back to ETS for a monthly payment of $82 per month, which gave purchasers a fixed 14% annual return on their investment. However, the phones didn't generate enough revenue for ETS to make its payments, and the company relied on funds from new investors to pay its debts. Eventually, ETS became insolvent and declared bankruptcy. Upon declaring bankruptcy, the Securities Exchange Commission, or SEC, brought a civil fraud enforcement action against Edwards in federal district court, seeking a preliminary injunction and an asset freeze. In response, Edwards argued that the sale and leaseback agreements didn't constitute a security, that the SEC wasn't entitled to an injunction, and that the asset freeze was unwarranted. The district court granted the SEC's motion, and Edwards appealed to the 11th Circuit Court of Appeals. The 11th Circuit reversed, holding that the sale and leaseback agreements didn't constitute an investment contract under the third prong of the Howey test, because they offered investors a fixed rate of return. The United States Supreme Court then granted cert.